Good evening, everyone. Welcome to the Public Opinion Court, where I am the creator of the Public Opinion Court. My name is, of course, Thelma Anderson, and I created this platform just to educate you all on all things legal because everybody has an opinion, but don't nobody want to pay attention to the reality of things. So, the Public Opinion Court is a space for you all to ask questions, to engage, to talk about whatever y'all want to talk about. This is a safe space. Everybody can participate. You can ask questions. Hold on, y'all. Like my internet, I need to make sure this internet is back up because it's been giving me the blues today. No, don't do that. Can everybody see me okay? Is the service okay? Is it fluttering or flickering on your end? Somebody hit the comments and let me know. Because I want to make sure that we don't have any interruptions because I have to record on my hotspot because my internet is playing crackhead games right now. And I don't know why. Hold on 1 second. How does it look now? Because it still look like it's flickering a little bit on my end. I may have to go out and restart this whole thing over because I don't want it to be distracting. It looks like it's a little stabilized now. Okay, well, I'm going to get into it. So, as I stated, this is a safe space for you all to ask questions, be yourself, don't be afraid. Because the one thing that I love doing is educating people on what's going on in the law so that y'all won't be out here with these flawed opinions about things. So just to give you a little bit of background, I was a litigator in criminal for about 6 years, tried over 50 criminal and civil cases. I understand the discovery process from start to finish with putting on trials and things like that. So I literally saw this happening today because I've been following a YSL trial since the beginning. So with me seeing this, I was like, let me break it down for them because I'm pretty sure they do not know what is the reality of when we're talking about a whole mistrial. So we all know that this case is the shit of the shows. And it's so many layers to it, y'all, that even I get confused sometimes on who, what, when, where, why, and how. And I want to break down the fact that this happens. This is not something that's just not unordinary. This happens every day in courtrooms across the United States. It happened to Love today. It probably was happening to somebody else in another courtroom, in a different jurisdiction, in a different state, in a different city. However it happens every day. So I just wanted to first start by playing the actual video that scolded DA Love. So let me go to the video.
Other flooring on the part of, I truly am struggling with whether all of this is purposeful or this is just really poor flooring on the part of members of the state's team. It is baffling to me that somebody with the number of years of experience that you have, time after time after time, continues to seemingly purposefully hide the ball to the extent you possibly can for as long as you possibly can. And I really don't want to believe that it is purposeful. But honestly, after a certain number of times, you start to wonder how it could be anything but that, unless it is just that you are so unorganized that you are throwing this case together as you try it. And I am sorry to say that, but this case is being made much more difficult for everybody because of the haphazard way in which it is being presented. I'm going to take a recess for a few minutes. I'll have a ruling when I get back.
So what we just saw is basically what judges typically do when there's issues with discovery that is coming in during a trial and has been repetitive. And it has become a pattern to where it becomes frustrating to have a fair and impartial trial if there is outstanding evidence that is just coming up or was overlooked and was not properly organized. So let me start off with the reason why this particular judge was frustrated. And I want to also state that the judge is not off the hook for this because this is the judge's responsibility is to make sure that all sides have complied with their duties before, during, and in the furtherance of a trial. So to give y'all an example, before I go to the actual breakdown, because I created a document to go over this whole discovery thing so that y'all can understand what it all looks like and why a mistrial was not actually granted, because it has to rise to the level that is so egregious that a mistrial has to be granted. So it didn't happen in this case because it didn't rise to that level. And you got to look at it. Is it a curable issue? Can the issue be cured in the amount of time that is allowed it for this particular trial? And we know that this case will be 11 months in starting next month, is within a couple of hours. It'll be 11 months that this case has been going. It'll be 12 a year in November. So because of the length and this continuation of going on, the judge is like, we are still knee deep up into this. It does not rise to the level that I need to be concerned to grant a mistrial. We can cure it, but let me put this in the face of the district attorney so that they can understand that I'm not playing. I'm not the 1, the 2, the 3, the 4, or whoever had the case before, which was Glanville. So when you're talking about discovery, there was this judge that I used to try cases in her court. And She was a Black judge. She was very procedural. Like, she was organized to the T. Like, she was going to make sure that the defense had everything that they needed. She was going to hold the state's foot to the fire. And I told y'all this internet is playing in my face at this point. Um, but back to what I was saying with is it back to what I'm saying? Because it's lagging again. Oh no, it didn't. Let me let this internet wind up. This internet is not my friend today. So hold tight, because I don't want it to be flickering it looks like it's not flickering. Hold on, y'all. Mm, okay. Now it's getting on my nerves. Okay. We gonna hold on to a prayer with this, because I don't know what this Wi-Fi is doing. Maybe it's being bipolar. Let me see. Done. I'm gonna try one more thing, because I don't want this to continue to interrupt. Right? But it's okay. We working through the technicalities. I'm gonna go back to this hotspot. Okay, I'm gonna stick to this hotspot for now. Um, but that's playing games. And why is this thing connecting to my neighbors? I feel like something don't want me to go live to educate y'all on what's going on. Okay, I'm back. Like, it's going to flicker, y'all. I don't know what's going on with this whole internet. The Russians are trying to come in and take over my internet to interfere with the election because they're down here eating the cats and the dogs. Um, but back to what I was saying. Discovery is controlled by the state. And when I talk about a judge, the judge houses and owns the responsibility of making sure that both sides comply with their obligations when we're talking about going through the trial process. So let me pull this up so that I can go ahead and present this, because I don't know what's going on with this internet. So let me bring this to the stage. So hold on, let me edit, move this over a little bit. I don't want that person on here. Go back to this. Come to the stage. So what I did was just like a typical breakdown of what actually happens in the criminal justice system. But let me change this layout because I don't understand what this layout is doing, because I definitely don't got no friend and I didn't invite nobody to this. The devil is a lie. I think this thing is I think my live is a little tainted today. But we gon' okay. So what I have done is okay. So what I have done is I have did a breakdown of what discovery actually looks like. The reason why I did this is because I wanted y'all to get like an overview of why is not likely in a situation like this. So when you look at it, this is how everything aligns when you're doing a criminal investigation. So under the picture, this is where it starts, and on the right side, or if it's on your left side, you're going to see the start to the finish. So it actually, criminal investigations, for example, like a murder, it starts with a police investigation. The police have to investigate. And when they're doing their investigation, of course, they have to collect all of the evidence. All of the evidence has to be put in crime scene approved packaging, and it has to be sealed, and it has to be documented, and it has to have logs of who, what, when, where, and how, when this evidence came in and out, and it has to track the custodial records of who has had possession of the evidence. So let's say, for example, if the police determine that they have a suspect, what they're typically going to do is go to a magistrate judge and get a probable cause to search warrant if they need to start with a search. So I'm going to initially go and search whatever location that they have deemed inside of the probable cause affidavit to get a search warrant. Let's say that they find a murder weapon. And after they find a murder weapon, they go and they know who their suspect is. It's the same type of weapon that was used to murder said person or unalive said person. So what they typically do after that, they go back to the magistrate judge and ask for an arrest warrant, because now they have probable cause to arrest this person based off of the investigation, based off of the evidence that they have collected, based off of the statements that they have received during their investigation. So let's say a magistrate judge or a judge signs off on the arrest warrant. Well, now it's time to go and arrest this individual. They can ask for this individual to waive their Miranda rights, or they can just decide to go ahead and arrest them, put them in custody. Of course, typically they're going to want to get a statement, but if they lawyer up, let's go ahead and say that, okay, they're arrested, they're put in jail, a bond has to be set. Well, then after all of that, after they're in custody for a short time or however long, they then have to proceed to doing sending it over to the district attorney's office. Once it goes to the district attorney's office, that is when the responsibility of discovery actually starts for the state. So at that point, once a case that's like a murder goes into the intake process for the district attorney's office, which is also the grand jury process. Any murder case is going to have to go through a grand jury. It's not going to automatically be true billed. It has to go through to make sure that the officers had probable cause, and of course, the arrest warrant was legal and sufficient. So after, let's say, it goes through the intake process, they set it for a grand jury. The grand jury at that point is going to decide to true bill or no bill. If they decide the true bill, that means it's now getting assigned to a district attorney. Let's use DA Love, for example. It now gets assigned to her. Now, guess what she has to do? She has to now make sure that all of the evidence that is synonymous for this particular case that has been assigned to her, that she has care, custody, and control over all this particular evidence. The reason why, this is important is because there is a case that many of you may or may not know about, which is called Brady v. Maryland. This case puts the responsibility on the prosecutors to make sure they turn over everything. Because when we're talking about taking away somebody's life, liberty, freedom, we got to make sure that these individuals are upholding the standard of the evidentiary process. So once they go through that, they have to look over all of the discovery, make sure there's an assigned defense attorney. Let's say the defendant hires an attorney like Steele. Steele is on the case. We know Steele gonna pull up, be like, hey, what my evidence? I need mine because I need to get my client out. So we have Steele rolling up on the district attorney. Guess what? The district attorney at that point is supposed to put the defense attorney on the portal where all of the discovery is to be housed, or if it's not housed on the portal, they have to have the ability to make it available to the defense. And this is under the Brady v. Maryland landmark case that literally changed how prosecutors are what they are responsible for. So let's fast forward after the original discovery has been tendered. Well, guess what? The investigation is ongoing. The state is still talking to witnesses, and let's say witnesses are saying something different than what they said to the police, and guess what? They got to turn that over, make notation, and immediately release that to the defense. Well, let's say that they call Lil Woody, and Woody say, and this is about 6 months into the case, y'all. They believe that they have all of the evidence. They call Lil Woody come down for an interview, and he be like, oh yeah, I forgot to tell y'all where I was hiding one of the bullets that go with the murder weapon that y'all are asking me about. And at that point, if you are a Black woman, you got on a wig, you are ready to snatch your wig off because one thing the defense attorneys like to do is holler Brady or holler the Michael Morton. So another landmark case is the Michael Morton Act, which is a case that happened late 1999, early 2000s, where this coach in Houston was arrested for murder, convicted. Come to find out, the detective was housing some of the documents that was exculpatory and mitigating for Michael at his house. So guess what? He had to be released. The conviction had to be was overturned, and then they implemented the Michael Morton Act because they added another layer of all exculpatory and mitigating, which means that it don't necessarily have to be important to the state, but it's important to that defendant's rights, his constitutional rights. So let's say, Lil Woody was like, yeah, I got one of those shell casings. I mean, one of those bullets y'all been looking for. Y'all probably can use it to test to see if it's a part of the gun that y'all looking for. The DA at that point has to immediately turn over that statement, and then get to work, which means that they get their investigator involved. The investigator goes out to whatever location, search it, or even get the detective involved so there can be another, some more evidentiary measures to cover. So let's say that they find the shell, the bullet. Now it has to go through forensics. That's a whole nother ball game. So the reason why I'm saying it is because discovery does not stop when the agency, which is the police department, turns it over. Things can come in and happen during the process of the trial. So what happened today, the reason why I bring that up is because this is where judges come in at. This is why I say judges are not off the hook for things like this, because you all also have a responsibility to make sure that everything is being turned over. And the reason why I put a comment under Charlemagne's post is because a mistrial, it did not rise to the level of a mistrial because the judge has to look at it from all cylinders. And in this particular matter, although I do feel that there's a level of organization that has to go into such a high profile, high stakes case, the judge could have, and I'm talking about Glanville, because the new judge, she came in on the end of it, or the middle, not the end, the middle. She came in July, so it was the middle. So what I would have recommended is something that a judge that I would try cases in. She held extensive discovery hearings. And in this particular matter, I believe that there should have been a discovery hearing that lasted a month to go over every piece of evidence, make sure that it is turned over, make sure any statements that needed to be argued regarding evidentiary purposes, or whether it took 6 weeks. I would have had them in there for 6 weeks going over every piece of evidence, every piece of evidence that was in dispute, calling in the agency to make sure that they are on the record saying that they have turned over everything to the state, having the state make a proffer for everything on the record, because when we're talking about appealable issues, evidence has been one of the biggest hot topics of appealable issues because of the fact that something may not have been disclosed. And when the judge was scolding DA Love, I think it was warranted to a certain extent, but I also think that she showed grace to DA Love because the mountains of evidence that is upon her, it doesn't absolve her of her duty, but I believe that the judge, Glanville, should have taken it upon himself to structure this case in a way that all of these issues would not continue to cause a delay. It's causing even more delays because now you have even more things that may have been overlooked because they can make honest mistakes, but is it really worth the mistakes are so monumental to a defendant whose life and freedom is on the line. So you can't make these type of mistakes. And the reason why I said I feel like the judge should have done everything possible, even this new judge, she should have held a discovery hearing that lasted 6 weeks for her to get up to date and up to par with this particular case, because it's so much has already been ruled on. It's indescribable about the mountains of evidence that will be subjected to some issues based off of how extensive it is. So when we're talking about a mistrial, a mistrial has to rise to a certain level, y'all. You cannot automatically get a mistrial. Let's say, for example, somebody makes a statement that is so egregious that it cannot be undone. Mentioning old offenses that have convictions, some things cannot be undone. This evidentiary issue can be undone because there's still have time to cure and make it available, and also explain why it wasn't available, and then give the defense they have ample enough of time to review this. So those are some of the factors that a judge will look at to determine if a mistrial should be warranted in cases like this. And I think she made the proper ruling. I think the scalding of DA Love was unfortunate. And the reason why I say that is because majority of the time, the individuals that look like us are the most prepared. I would say that. Let me see. That's my question. How can a new judge start in the middle? Did she have to read everything from the beginning? No. A judge does not have to start from the beginning. I've had cases where a judge had an emergency to where a new judge had to come in and take over. I've had a judge pick the jury, and then the sitting judge, the presiding judge, is the one that presided over the case. So it doesn't matter what stage. What they're looking for is the person equipped to come in. And you saw Auntie, the original replacement, get somebody else to do it. So now we have Judge Thornton, who I believe she would have been more efficient than Glanville. It was a lot of things that Glanville did that I did not understand with such a high profile case, why it wasn't organized in a way, why they was taking so many freaking breaks, why certain evidence in certain hearings was not completely flushed out, because it could have been. Trials do not take this long. And the fact that they're putting on trial, like different cases from different years, this is the reason why it's taking so long. When I first started following it, I just knew that he was on the way to prison. If I remember correctly, his lawyers are terrible. Now I wonder who's worse, the defense, the prosecution, or the dang judge. Listen, y'all, strategically, the defense made a good decision with making this, agreeing to try these cases all at once. I think the state should have tried these cases separately. I would have started with Young Thug. I would have started with the main person. I would have done that. And then I would have proceeded to try the others. You said, where is Funny? Baby, Funny is she is working on her campaign. Yes. She is working on her campaign, y'all. Funny was actually in Dallas. Well, Texas. When was she in Texas? Last week? She was in Texas. So Funny is out here campaigning. She out here getting money for her campaign. And Funny, and what's crazy is, y'all, Funny is the go-to DA when trying RICO cases. Like, the girl is just phenomenal. They are trying to get Funny, y'all. Y'all, they are trying, and it's so sad. But this is something that happens to Black prosecutors all the time that are in power. This happens all the time. It's not something that does not happen, which is unfortunate. So that's the reason why I tend to give more grace to those who are minorities, because we understand the fight that goes into it. But it doesn't mean that a person should be unorganized, unprepared. It's so stressful. I believe that these lawyers, all the lawyers, are going to have PTSD from court, because you cannot be in the fire pit for that long. Like, being in the fire pit for that long and not having a vacation or a time off, y'all, this case is not for the weak. But that's one of the reasons why I wanted to break this down for y'all. But while y'all are here, I need for y'all to like, subscribe, share this content, because as I'm growing this platform, because I'm working on something with the Public Opinion Court, because I own the name and I have people who are trying to copy or use the name similar that, may warrant some, things to come down the pipeline. But I need y'all to like, subscribe, and share this content. Let me see. Speaking of Woody played in them people's face. I like Woody, but I feel his entire statements of snitching were true. He backtracked, things became public. He gonna be a target. Let me just go over that for a little bit, y'all, because I want to break that down to y'all for also, because this is where I also feel like the state dropped the ball. I've had witnesses that have went completely left. And you got to be prepared for that. I've never trusted a witness to get up there and be who they were when we have went over the case, because people get nervous and the nerves start kicking in. But let's talk about this particular issue. When you have a witness that goes on a memory lapse, I don't tussle with them. I don't tussle. I just get them to say what they don't recall, and I pull out that the statements that they made, the proffer, the implication, the deal, the video, and I just pass the witness. I'm not gonna be like, oh, but on this video you said this, because I already know if I continue to let this person talk, they're going to continue to be who he was. That was a big mistake that the prosecutors made, was entertaining him and tussling with him. I literally would have taken his, let me see if I got some paper over here. I would have literally took the plea paperwork, read each line. Is this your signature? Okay, over here. Is this your signature? Is this your signature? Is this your signature? Then I would have pulled out the video of the plea Then I would have pulled out the transcript. Then I would have went to the interview with the detectives, and then I would have been like, pass the witness. And I would have let the defense tussle with him, because at that moment I got everything that I need. I did what I needed to do, and I passed them along, because the video with the officers, which I would have utilized the officers in explaining to the individuals, the jury, that this typically happens, but we typically get the best current memory of individuals or suspects right when it happens, because they don't have time to prepare. This man has had almost a decade to prepare for some of these offenses, and the fact that he's labeled a snitch. He's trying not to be a snitch, and you still are a snitch. So I wanted to break that down for y'all, just so y'all can kind of see what I would have done differently in how this stayed into the hands of Woody. And the reason why it was detrimental, because now all of the other snitches are doing the exact same thing. Oh, baby, I'm not going to tussle with you. We ain't tussling. Because I'm going to control this witness. I'm going to make sure that this witness do everything that I want them to do and want them to say. Let the defense play those games. Let the defense contradict. Then I'm going to come back on cross. On this transcript, you said X, Y, and Z. Oh, Woody got immunity, but it's subjected to him testifying correctly. Now it's up in the air. And plus, he got another warrant out for his arrest. I don't know what he did, but yeah. So that's what I would have done. And that's my little 2 cents on that, y'all. And like I said, like, subscribe, share this content. I wanted to come on here and break this down for y'all. And like always, I make it my goals and missions to educate you all on some things that you may not understand, so that you can get a better understanding from somebody who's done it and who has seen it happen over and over again. The public really think he threw that case. No, ma'am, sir. Definitely a snitch. Either the streets or the police going to get him. The case, he didn't throw the case because there are other ways to prove conspiracy and relationships. Like, for example, in the situation with Young Dolph, the reason why one of my videos that I did, my lives I did last week, that I said that I don't believe that Gotti knew or had any reason to know. This is just my hope. Because these lawyers was paid in the name of CMG allegedly, then it opens it up for investigation. And just because you don't have any involvement doesn't dissolve you because of agent and apparent authority when we're talking about business owners. Because his brother had a executive role, it will tie him to any criminal behavior that his brother aligned with while he was an executive. So that's the unfortunate side, and that's what business owners don't know. Luckily, at the BYOB firm, we teach entrepreneurs how to make sure that anybody they bring into their business, they understand ain't no crimes being, you don't get no agent and apparent authority to bind us to any crimes that you may want to indulge in. Like the other guy that they were threatening him with jail. Yeah, because when an individual implicates, which implication means that they are looking for a better deal. Immunity means that you won't go to prison. They just want you to be truthful in what you did when you took the plea. So in any aspect of that, if you don't comply or you don't do what you said that you were going to do, yes, they're going to at that point clink clink, deal is off. You came in here and showed us your. Now we about to show you to the cell, and you about to get a new ID number, or we probably give you the old one. We whichever works for us. So yeah, it looks fun. It looks funny. He's making a lot of money right now, hopefully, but y'all, no, no. Mm-mm. But like I said, I do this so that I can educate you all on, because everybody have an opinion, but everybody don't understand the reality, don't necessarily align with opinions. That's why it's an opinion and a reality. And I'm going to leave you with this. The only way you know something happened 100% is that you were there. The only way you know something happened 100%. That's why if you are in the comments going back and forth with somebody about somebody else's business, you know something happened 100% if you was there. So thank y'all for joining this live. Thank y'all for always supporting and showing up as I continue to grow this platform. Tell a friend to tell a friend. Join my public opinion group on Instagram, because that's where I also do some updates and some information. Thank you, thank you, thank you. Hold on. It seems like they expected everyone to plead. That's why. No, they didn't expect that. It's just that it's so much evidence that you have to put people in place, and the government has the resources to have multiple prosecutors assigned so that things like this can be organized. That's not an excuse. But y'all have a great Monday night. And until something else breaks, if y'all want me to break something else down, always hit my DMs. I love talking to y'all, or hit me in the comments and say, hey, break this down. I don't care, whatever post. I'm here to be a vessel, and thank y'all for joining.